Welcome to Pop Your Biz. I'm Amanda Butler Schley, your go-to business lawyer and purveyor of all things pop culture. Join me as I break down today's hottest legal headlines into bite-sized pieces. We use the lawsuits of your favorite celebrities and worldwide brands to teach you how to keep your business on the right side of the law. Let's dive in. Today, we're really going to look at Lizzo's defense team and their defenses that they are asserting, and go through each of those defenses to see what we think is going to have merit and what we think falls short. I've got my incredible associate, Kelley, with me today. Welcome, Megan.
Hi, thanks for having me.
Yes. And I thought the best thing to do would probably be to dive right in. This motion to strike is much shorter. That's one thing that you'll notice. It's only 25 pages. Why do you think that is, Megan?
There is a page limit. So here, as opposed to a federal court where there's unlimited pages, and like with the complaint, there's unlimited pages, so they can really get into the nitty-gritty of all the facts to tell their story. Here with the motion to strike, there's a page limit of 25 pages. So they are on a time crunch and a page crunch to dispute all of the allegations in plaintiff's complaint.
So the key defense that we're going to see here is called an anti-SLAPP defense. Can you tell everybody, it's a very unusual defense to have in an employment law case. Oftentimes, none of our employment law clients are going to be able to use an anti-SLAPP defense. What is an anti-SLAPP defense?
Anti-SLAPP stands for Strategic Litigation Against Public Participation. There's 32 states that have these SLAPP laws, or anti-SLAPP laws, I should say, but California has the strongest. And what it means is that defendants can bring a motion to strike, like Lizzo has brought here, to challenge the complaint if they can show they're being sued for any act in furtherance of that person's right of petition or free speech under the First Amendment, or in connection with a public issue. So Lizzo here is saying that all of the allegations in plaintiff's complaint are of public issue.
That's so interesting. So that raises a lot of issues for me, or brings up a lot of issues, because most of our employment law clients are not going to have this type of defense. Should there be a less protected work environment if you are working for a company that is doing concerts or performances or dances? Is that what the law is trying to provide?
No, it's not. And so here they're saying it's of public interest because she is a global celebrity. And all of these allegations are a part of her global tour, which is of public interest. And so here we're really going to get into the facts, kind of a he said, she said, responding to all of the allegations in the complaint. And the goal is to bring all of these allegations within the creative process of Lizzo's tour to try to get them dismissed. So from a legal standpoint, whenever I'm responding to a plaintiff's petition on behalf of an employer, I'm looking for all of the defenses I can assert to respond to that complaint. And here they only stick to one defense under the anti-SLAPP statute. So it's really interesting that they're putting all of their eggs in one basket.
And back to the idea of the strategery of the whole situation, when we talked about how it was beneficial for the plaintiffs to bring suit in California state court as opposed to federal court, because California state laws are interpreted more favorably to employees as opposed to employers, that anti-SLAPP statute is not a federal statute.
It is not. There is no federal anti-SLAPP statute, and California has the strongest anti-SLAPP statute. So filing in California state court for this reason could have been a misstep.
Oh, wow. So interesting. Okay, let's dive right into the complaint. I'm going to pull it up on the screen. For those of you looking to follow along, we're going to put in the notes, we're going to put a copy of the motion to strike, the memorandums, and then some of the relevant declarations, because the declarations that the defense uses or introduces in this motion are all separate, and they have separate page limit requirements. So that's not part of the 25 page limit requirement. And we're going to see declarations from, it looks like 18 plus dancers and Lizzo herself. So we'll link those in the notes, and let me get that pulled up right now. The defendant's motion to strike, in which they have an introduction that's about 4 pages long that does get to the specific paragraph allegations that they're looking to strike. But we're going to just go ahead and focus on the memorandum of points and authorities first and go through this introduction. You'll see that they, in this introductory paragraph, are saying that the plaintiffs here have an axe to grind. Williams and Davis were terminated from their employment as big girls following a pattern of gross conduct and failure to perform their job up to par. Plaintiffs missed flights, arrived late and hungover to rehearsals, and drunk to performances, entered into consensual sexual relationships with male crew members on tour, exhibited a rapid decline in the quality of their dancing and professionalism, and ultimately conspired to make and disseminate an unauthorized recording of a creative meeting with Lizzo and the dance cast. And then they use a bunch of declarations that they have attached as evidence of those things. They say that plaintiff's wrongful conduct was uncovered and Rodriguez preemptively resigned to avoid termination, and proceeded to insult and interrupt Lizzo in front of the other dancers. On her way out, Rodriguez had some choice words for the dance captain, Quigley: "Fuck you and your Jesus shit." A few months later, plaintiffs embarked on a press tour, vilifying defendants and pushing their fabricated sob story in the courts and in the media. That ends today. So, interesting introduction. I mean, I think the attempt here, Megan, is to take back the narrative, or try to take back the narrative. I don't know if I'm feeling this introduction.
I'm definitely not. Remember, the whole goal of this defense, their anti-SLAPP motion, is to cancel these allegations and causes of action because they're part of Lizzo's creative process. None of this speaks to that. This is just a he said, she said of facts saying they deserved to be terminated. And this is a false narrative that they're playing because they were terminated. And I'm just not buying it.
Yeah, not my favorite introduction. Okay, they go on to say 18 members of Lizzo's touring company have signed declarations under penalty of perjury that directly refute plaintiffs' false narrative about their experiences on the set of Lizzo's reality competition series, Watch Out for the Big Girls, and as dancers on the special tour. The sworn testimony of these non-party witnesses and of defendants Lizzo and Quigley, backed by incontrovertible documentary evidence, including photographs and videos of plaintiffs and contemporaneous records of their words, intentions, and conduct, confirm that plaintiffs are not victims of harassment, discrimination, a hostile work environment, or any of the other tortious acts they have alleged in the complaint. Far from it. They are opportunists.
I think two things are interesting about this introduction. The first is that they're saying they were terminated for their performance when these dancers won a TV competition to be tour backup dancers because of their ability.
And we all watched it play out. That's what's
Right.
really crazy to me. It's like we have a video, a record of what happened there, and it shows that these two dancers won their spots as a result of this exhaustive search for good dancers. And this idea that all of a sudden they went from that to just horrible dancers, that's not, that doesn't seem to be the strongest way to counteract the narrative. The other thing that bothers me is that they say they have 18 sworn declarations from other dancers. Well, those are dancers that are still being employed. And anytime, we start in any sort of litigation representing the employer, if the employer goes to their employee and says, hey, we need you to tell us about an experience. Now, it's a sworn declaration. So it's, they are required to be swearing this under penalty of perjury. But it's certainly not a lot of employees, present employees, are going to say anything negative about their employer when asked
Exactly.
what happened. So to me, the idea that you have 18 declarations from other dancers, okay, that's a large number. So I'll give them that. The just the number 18 seems certainly like a large number of employees, but they are all employees. So that to me seems somewhat like not very strong evidence. So to lead with that again in the introduction, I don't know. Before they were held to account for underperforming and violating the terms of their employment, plaintiffs were defendants' biggest fans. In mid-April 2023, Davis applied to work with Lizzo on the second season of Watch Out for the Big Girls. And in her audition video, she heaped praise on the Queen Lizzo herself, describing working for her as an amazing and beautiful journey, and declared, "I looked up to her so much and I just want to follow in her footsteps." Hours after she was let go, Williams changed her flight so she could spend some more time with the dance cast and asked tour manager Molly Gordon if she could attend Lizzo's show. In a similar vein, after Williams's termination, her agent sent an email to tour management stating, "I know she appreciates all of the team Lizzo for the opportunity and is grateful to have been part of the team." Significantly, after plaintiffs returned home in late March of 2023 from the European leg of the special tour, which is portrayed in the complaint as a hellish ordeal, plaintiffs had the choice whether or not to continue dancing with Lizzo, and all three returned for the third leg of the tour. Then in bold, if they had been subjected to the appalling harassment and discrimination alleged in their lawsuit, why would the plaintiffs have chosen to return? This is not a fair statement or not a fair question, and I think is missing the boat in a big way, right? Like oftentimes as the employer representative, we're not wanting to say like the reason that, since they came back or since they didn't quit, it was a good work environment. That argument is not the argument that you want to make as an employer. As an employer, the argument that you want to lead with is that at all times we maintain the highest integrity work environment for our employees, and we strive to do it. And at any moment that we had knowledge that the work environment was sexually charged, or that there was harassment or discrimination, it is incumbent upon you to address it. It is not incumbent upon your employees to quit. And the idea that these attorneys thought that putting that, especially here in bold, as like some big gotcha Perry Mason moment, I think they also are missing the boat. I don't think that they're understanding really how to change the narrative here. This is not working for me. Yeah.
No, there are any number of reasons they would have chosen not to quit, and primarily being their backup dancers. This is the highest goal you can get as a professional dancer, is to work on a global tour. So of course, once you achieve that goal, you're not going to quit.
Yeah. I mean, and the idea that that's what they should have done, or that if the work environment was bad, that that's what they would have done, I think is really not a great argument to make.
Not at all.
Okay. So plaintiffs auditioned and competed to be one of Lizzo's big girls because they admired her, an artist, performer, sex symbol, and advocate for sex positivity, body positivity, diversity, and inclusion. Plaintiff stars rose along with Lizzo's as part of her mission to show the world that people who look like her can dance and perform at the highest levels. They received a leg up and an incredible opportunity to take their careers to the next level, precisely because Lizzo herself had worked tirelessly to break the stereotypes society imposes on outspoken, sexy, and confident plus-size women of color. Plaintiffs had it all, and they blew it. Instead of taking accountability for their own actions, plaintiffs filed this lawsuit against defendants out of spite and in pursuit of media attention, public sympathy, and a quick payday with minimal effort. Finally, okay, this is an introduction. This should have been paragraph 1. If I am making this argument about Lizzo and changing the narrative, I'm going back to what we all believe Lizzo actually is, which is a trendsetter, a groundbreaking performer, doing something that just being herself is in fact a statement, right? It's so, yeah, this to me should have been paragraph number 1. And everything, the narrative should have started here, and the narrative should have been everything that you know about or believed about Lizzo is the case. And what they're saying about her is not the case. And so I think that this should have been the lead paragraph, in my opinion.
I agree, but at the same time, my problem with this paragraph is that they're essentially saying plaintiffs were such fans of Lizzo that they never should have brought this lawsuit. And I've yet to see, and we're almost on the third page, how any of these allegations are part of the creative process to bring them within the realm of anti-SLAPP, which is the whole goal of this motion. So I get her wanting to change the narrative after such a salacious complaint, but they've yet to bring in the defense that they're writing on here.
And if they're trying to change the narrative, they should have put this third paragraph and made that the
At the top.
focus of this
Mhm.
entire thing, which is the Lizzo that you know and love is still the Lizzo that you know and love. She has never been, this is not some sort of Ellen DeGeneres type of Dr. Jekyll and Miss Hyde situation.
Right.
Lizzo is Lizzo. You love her and she is who she is. And these allegations are false. And let us give you specific facts that are going to do that. All of the specific facts that they put into this initial introduction are not doing it for me. So let's see what else they have to say. All right, so let's talk about the sexual harassment allegation. Plaintiffs allege that they were subjected to the hostile work environment because they're forced to go to the Banana Bar, which is in Amsterdam's red light district, against their will. Every witness has confirmed that attendance was voluntary and that there were no adverse consequences to those who did not attend. And then here we're going to have a lot of the references to the declarations of the other dancers. Contrary to her claims, Davis was not forced to do anything against her will at the Banana Bar. The next day, Davis and Rodriguez described their wild night, including when they went out to other sex clubs in the red light district after leaving the Banana Bar. That's a good fact, right? Like if you continued the party to other similar type venues, it's hard to claim that, that it was such a horrible environment that you never would have been in if you then go do similar things. So that's an interesting fact.
It is interesting, but also to me, when I read it, I think, so what? What does this have to do with Lizzo's tour and creative process, which they're not touching on yet?
Yes, very, very good point. Davis happily described that she touched a performer's breast and that the girl smelled really good. Plaintiffs also alleged that they were pressured to attend a show at the world famous Crazy Horse in Paris. All evidence flatly contradicts this claim. Davis sent a text message to Gordon enthusiastically accepting the invitation to Crazy Horse. I would really like to go. Photos and video of the 3 plaintiffs show them carousing and cavorting backstage with the Crazy Horse dancers, with Williams raising her glass as if toasting the event. That's interesting. I mean, the idea that you're at the Crazy Horse and they have video of you that they can show how you were behaving at the Crazy Horse. Then again, if you feel like it's compulsory or it's mandatory, and they do a good job in the complaint of saying nobody said you had to go, but if you didn't go, you weren't going to be treated as favorably as those dancers who went, which is certainly a demonstration of the power dynamic between an employer and an employee.
Right.
So,
And
you know,
Lizzo here is really saying it can't be sexual harassment if you liked it. And here are the facts showing you liked it.
ugh, and that doesn't play very well, Lauren.
No. We
No.
don't blame the victim.
No, it does seem a little bit like victim blaming, a little bit almost like gaslighting in a legal memorandum.
Yes. Yes.
But I guess again, I'm like, all right, so you went to the Crazy Horse, you went to the Banana Bar. I'm back to the place of what does that have to do with a sexual or a hostile work environment claim in general? Because the hostile work environment has to relate to your gender, right?
Right.
And here we have all girls going and participating in this, and they even include in the complaint a whole description about how there was a male person that also was experiencing the same
pressure to go. Yeah, a
encouragement.
male
Yes.
crew member. Mhm.
Yes. So it's like, again, I think this is another missed opportunity on the defense's part. If I was Lizzo, and granted, I'm not a California attorney, but I think they're missing a huge opportunity here. And then the opportunity that the defense that they're going with, they're not doing a good job yet of showing how it's related to a performance.
Right.
So they're just saying that they liked it. They went to the Crazy Horse and they went to the Banana Bar and they liked it. Okay, just like you said, she said. Another fiction is plaintiff's allegation that Quigley made constant, unprompted comments about graphic sexual topics, including Davis's virginity. Multiple witnesses attest that Quigley did not initiate sexual conversations or spontaneously simulate sex acts. So this relates to the faux fellatio description. To the contrary, it was Davis who spoke out about her masturbatory habits and freely discussed her virginity while cameras rolled on the set of Watch Out for the Big Girls. Okay. So again, it's just trying to show that the plaintiffs are lying.
Other than wanting to change the narrative, all of these facts are just fluff.
Right. I mean, look, they put this all under this heading that's called the plaintiff's sexual harassment allegations lack merit. Okay. Well, if they lack merit, why wouldn't you file a motion to strike the allegation in its entirety for failure
Right.
to state a legal cause of action?
Exactly. And they didn't.
They didn't. It's a huge missed opportunity, in my opinion, to just
I
rely on
agree.
the anti-SLAPP, because I don't think the sexual harassment allegations would have stayed in. That's
I
what
agree.
I think would have happened. Now, we're not California lawyers, but I think it's a huge missed strategic opportunity. And it looks like now we're going to do the same exact thing with the racial discrimination claims, where they're going to paint those as also, quote, unavailing.
Mhm.
Plaintiffs contend that they were discriminated against on the basis of race because tour managers purportedly called members of the dance cast lazy, professional, and snarky, and accused them of having bad attitudes. In fact, plaintiffs were criticized because they were not dancing at the level expected of them and were often late and unprepared. Not a single witness observed or experienced racial discrimination on tour.
And this is again where you're asking employees to say, hey, show us this example of racial discrimination about your boss. And I don't know any employee that's going to come forward and admit to that.
Right. Yeah, I agree. I think it's just an opportunity to try to change the narrative. Now let's talk about religious harassment. Plaintiffs allege that they were victims of religious harassment because they were forced against their will to pray before rehearsals and shows. Every member of the touring party attests that no one was pressured to pray or faced punishment if they did not participate in prayer circles. Plaintiffs also falsely claim that Quigley created a hostile work environment because she proselytized aggressively to other dancers against their will and exhibited hostility towards those who disagreed with her religious values. Numerous witnesses testify that they did not observe Quigley harassing people about religion or treating dancers differently based on their religious beliefs. So again, a lot more of the same, where other dancers say that's not true and just disagree.
Mhm.
To the contrary, Quigley treated everyone with love and respect as dance captain, regardless of their religious beliefs. Interesting.
Okay.
Plaintiffs' own religiously oriented messages to Quigley are inconsistent with their harassment claims. Well, we would have to, I guess, look at the declaration of Quigley, which I do think we should maybe look at. And so maybe let's look at Quigley's affidavit or declaration and Lizzo's declaration, and we'll kind of conclude with that. But again, I don't see the point of this. And I don't see the point of the declarations when the declarations are just offering evidence to try to say that the evidence that the plaintiffs submitted is not true. But that's not where we're at, right? I mean, that's not the point of this motion, is to disprove that what the plaintiffs are saying. It's actually, the motion, like you said, is to show that all of this is in connection with a dance performance, which is protected under the First Amendment.
Right. Typically, in a motion to strike, you only look at the four corners of the complaint and you cannot introduce this other evidence. In an anti-SLAPP motion, you can, but these declarations, all in support of the motion to strike, they miss the mark at showing how these allegations should all be protected under anti-SLAPP as part of the creative process.
You need to necessarily tie it to the
Right.
dance and performance process, and I feel like we're
Exactly.
missing the boat there. Okay. D, there's no evidence of disability discrimination or body shaming. Every other dancer on tour adamantly refuses or refutes plaintiffs' outlandish allegations of purported fat shaming and body shaming by Lizzo and her camp. Indeed, each witness confirms that Lizzo and her camp promoted a culture of self-love and kindness. Davis also alleges that she was subjected to discrimination based on a disability because she was made so anxious during a rehearsal that she urinated on stage instead of using the restroom. Every performer's testimony completely contradicts Davis's absurd claim that she had no choice but to urinate on herself during a production run-through. Others left stage during rehearsal for various reasons and were never penalized, scolded, or otherwise adversely impacted, even if they missed a cue, a mark, or number. I will say, I mean, there's something very bizarre to me about the idea that an employee will urinate on herself instead of leaving to go to the bathroom. I mean, I can't understand the type of personality that would not just go to the bathroom. Um,
But I
so
think it speaks a lot to the work culture and the environment you're surrounded in if you feel like you can't go.
Right. I think this fact that other people did do it is a very good demonstration of, like, something is wrong with Davis as opposed to something being wrong with the environment. Because if other people felt fine to go to the bathroom, and if in fact they did go to the bathroom and there was not any sort of negative consequences, is it reasonable for Davis to think, in whatever state of mind that she happens to be, that she can't go to the bathroom, otherwise she's going to get fired?
Hmm. But then again, we're not looking at Davis's reasonableness. We're looking at whether she can make a complaint or whether her allegations fall within the creative process. And certainly while you're on stage, if you feel like you can't leave,
Is that
I'm not
related to the creative process? I don't know. Yeah. I mean, I think she's trying to say that that's part of the disability, like she's being discriminated against based on her disability, and that this moment where she actually pees on herself instead of going to the bathroom is demonstration of how bad the environment is. But if everybody else in that environment went to go to the bathroom, it just makes it look like you're a little bit out of touch, or
Mhm.
maybe unreasonably interpreting the environment. Plaintiffs claim Davis was the victim of disability discrimination because she was interrogated, insulted, and body shamed by Lizzo and Scott during a private meeting. Testimony of everyone else present at the meeting refutes this characterization. Rather than an interrogation, Lizzo and Scott initiated a caring and supportive conversation, proposing accommodations to protect Davis's mental and physical health and well-being. Other members of the touring party also felt genuine concern for Davis because she seemed unwell, both in terms of her lax hygiene and health and her mental instability. Many observed that Davis's own insecurities led to her to twist Lizzo's offer of support into something nefarious. All right,
So
that
what should
lands.
have happened here is the employee should have requested accommodations for these different disabilities, whether she needed more bathroom breaks or later on, as we're going to get to, if she needed to record conversations. These are accommodations she should have engaged in the interactive process for under the ADA.
And how does that work, Megan? Just so that the audience, so that our listeners understand that the interactive process under the ADA, if you have a disability and you come to your employer and you say, look, I have extreme anxiety, binge eating disorder, and I'm depressed. I need to, have a shortened work day, or I need these special accommodations. And typically the employee is able to ask for whatever they need in order to be able to do their job well. And then the employer, as part of the interactive process, has to say, well, we can do this, but we can't do that. Or,
Right,
this part of your job requirements is that you are physically at dance practice. There's no other way around it. In order for you to get better, you have to practice. But
right.
should dance practices go on for 12 hours? I think
No,
just in,
that's the thing, it needs to be interactive. So the employer doesn't have to give you every accommodation you ask for. You engage in a conversation to come up with solutions. They can't be unduly hardship for the employer, but also the employee needs certain accommodations to help with their disability. And so it's a balancing act of what the employee needs versus how much burden it's going to place on the employer. So
yeah.
here, I don't see the problem with having built-in extra bathroom breaks, and limiting the rehearsal time to 12 hours, if it should
But
even be
there
that
is
long.
no reference in the complaint at all. There's no factual recitation that she ever asked for any of those things.
Right. No.
Yeah. In fact, she just basically says, I was so afraid I didn't ask for anything. Well, then it becomes like, well, should the employer have anticipated your requirement or need for those things because they knew that you have anxiety, binge eating disorder, and depression? And the answer to that might be yes. Then, in that same vein, what they're saying is, well, we went to her and we had this meeting in which we said, we notice that you're struggling, and these are some accommodations that we're willing to offer you. But the way in which Davis paints those accommodations, it's like basically saying you can take a break.
Mhm.
Well, nobody wants to take a break. That's basically saying you're not going to get paid. It's not saying you're going to have a paid leave of absence. They didn't offer
Right.
paid leave. They said, if you
Right.
want to go, go. Well,
Yeah.
I don't see how that's an accommodation, right? Like, I don't
No.
even think that that's an appropriate offer of an accommodation.
No, because I'm sure she's worried about her spot. Am I going to get replaced while I'm on the break?
Yeah.
Will I be able to come back?
So I think that this paragraph where they talk about that, this was really a meeting with her, to be caring and supportive. Plaintiffs claim they were subjected to harassment, but they repeatedly failed to avail themselves of the grievance procedure put in place for them. On the one occasion when they did, the issue was swiftly and appropriately addressed. Yet plaintiffs ridiculously gripe that the defendants failed to prevent or remedy issues that nobody else on tour observed or experienced, and which plaintiffs never reported to the tour management. This is actually a very good argument, right? Like, with regard not to the anti-SLAPP motion, because
Mhm.
again, we're way off topic, but
Right.
on whether or not they can sustain an allegation for um, discrimination, ADA discrimination, or racial discrimination. If you've never brought it up to tour management and you have an employee manual or procedure manual in which the way in which you address a grievance is you go to your manager, and they do talk about going to Quigley, right? They
Mhm.
all talk about going to Shirley and Quigley and saying, I want you to stop preaching to me so much, or I want this, or I want that. And then they even talk about going to a higher up, and never getting very far. But if there is a procedure mechanism in place, which they demonstrated that they knew about because they actually talked about that in the original complaint,
Mhm.
and they failed to do it with regard to these other types of issues, I think that's a real problem for them. So I think that's a good point. Again, it's buried here on, what are we now, on the 14th page of 25. So they're making good points, but they're not doing it in a way that, to me, I think, is going to get them very far. But now here we
And
are, finally,
okay.
to the anti-SLAPP standard. So why don't you take over from here and let's talk about the anti-SLAPP legal standard?
Sure, yeah, that's why we have all of these declarations, is because the anti-SLAPP law is a two-step process. First, defendants, here Lizzo, has to come forward showing that the challenged causes of action arise from acts in furtherance of the right of free speech in connection with a public issue or an issue of public interest. Here she's claiming her tour and her TV show are matters of public interest. So once she makes that showing, the burden shifts to plaintiffs to demonstrate through competent and admissible evidence a probability that they'll prevail on each cause of action, which is interesting because we've just filed the complaint. What evidence do plaintiffs have to come forward with? We haven't done discovery, so it's almost like they're fighting a losing battle to begin with.
Which is, again, that's why this is such a powerful defense. This is one of the most powerful defenses that I've seen. So back to the strategy of the plaintiffs, to serve up a lawsuit in which this defense can be used, whereas if you would have filed in federal court, the defense would never have had an anti-SLAPP defense. That could have been a real strategic error.
Right. And it's also interesting that California has an anti-SLAPP back provision, which allows defendants, if they bring this motion and they win, they can file a suit against plaintiff for damages and attorney's fees in connection with the original anti-SLAPP complaint.
So you're telling me if the defense here prevails on getting rid of any of these claims, the defense will be able to file an slap back motion against the plaintiffs and get their legal fees back
Yes, and damages.
and damages. Ooh, that could be a huge number, because the damages here, right, could be the damage to Lizzo's reputation. Do you think that would be included as damages?
I do. At least they would assert it. All of
Yeah.
this media attention surrounding the complaint has damaged her reputation. She's come out with several negative statements, so I think the damage to her reputation is substantial.
It is substantial. So I really think, again, they're opening themselves up to a huge can of worms by potentially being liable for Lizzo's defense costs on anything that doesn't get past this motion. So, ooh, that could be a very big number at the end of the day,
Mhm.
which makes me think they're going to want to settle this very quickly. We shall
Yes.
see what happens. And Lizzo might want to settle it quickly too, because nothing good is going to come of this from Lizzo's side.
No.
Lizzo could ultimately prevail in the end, and maybe that's what, kind of um, puts her reputation back to where it once was. But more than likely than not, this will be 2 years of the same allegations coming and being discussed over and over again. And so, again, a quick settlement, right, might be in the cards.
Mhm.
So let's then talk about the causes of action arise from protected conduct. Protected conduct is the any time that you're trying to do a performance, or you're preparing for a performance, or you're just generally of public importance. All right, so the alleged activity forming the basis of plaintiff's complaint. Plaintiff's claims stem from defendants' alleged speech and conduct in the creation and production of Lizzo's television show, Watch Out for the Big Girls, and her global stadium tour, The Special Tour. The complaint alleges 9 causes of action arising from almost every stage of the creation, planning, and execution of these 2 forms of creative expression, including the development of plot lines for and filming of an episode of Watch Out for the Big Girls, the production of an on-camera interview for the series, pre-show rituals and cast outings to encourage bonding and provide creative inspiration, evaluations of the dancer's performance and professionalism, an investigation of employee misconduct, the running of rehearsals and production run-throughs, and communications regarding operational aspects of the tour, budgetary restrictions, and compensation for performers. I think that's finally, we got a picture of how they're going to put all of this into this, how they're going to fit all of this in their defense. All right, so take us through the hostile work environment section.
Sure. Here they're saying that these outings to Banana Bar and having Davis participate in a nude photo shoot are the allegations of sexual harassment.
That's it. They're basically saying they've condensed everything down to the nude photo shoot. So
Hmm.
nudity against their will, the Banana Bar, the Crazy Horse in Paris, alleged statements by Quigley regarding Davis's virginity, alleged sexually explicit statements and gestures by the dance captain, alleged sexual harassment by a tour bus driver.
But they're just casting a wide net and saying that all of these different activities were related to either the show or the tour. And so they're covered under anti-SLAPP.
All right, third cause of action, Quigley's alleged statements regarding religion and sexuality, allegedly forcing plaintiffs to participate against their will in group prayers before rehearsals and performances. And then we have the racial harassment, which are the claims where they called the dancers lazy, unprofessional, snarky, and having bad attitudes, and an alleged statement to Rodriguez that tour management did not know of any complaints about her job performance. I think what they're just doing here is setting up each of the facts in the petition that they claim fall under the cause of action. And
Hmm.
so I think what they're going to do is hopefully come back and give us the actual
Right.
connection that we're looking for.
These are all the
Six,
facts they want to strike out so that when you're left with what isn't stricken by the court, you have this bare bones complaint and there's not enough to move forward. But the way this is written or drafted is confusing, it's hard to follow, and it's not very legally persuasive, in my opinion.
agreed. Um, okay, so let's talk about the disability discrimination. Alleged statements by Lizzo in a personnel meeting with Davis and choreographer Tanisha Scott about accommodations to protect Davis's physical and mental health. Davis allegedly being made to feel so anxious during a production run through that she believed she could not leave the stage and she urinated on herself. Alleged statements by Lizzo that weight gain could result in termination as a dance cast member. All right, seventh cause of action, alleged statements by tour management and BGBT accountants to plaintiffs and or their agents to not take other jobs during potential tour dates or remain on a soft hold when negotiating employment terms and scheduling performances. The eighth cause of action is the assault by Lizzo, alleged statements and conduct by Lizzo at a dance cast meeting during the special tour regarding personnel issues. And then the ninth cause of action, alleged unconsented confinement of Davis by the tour management and security while they were investigating her recording the previous conversation with Lizzo. All right, so here we have finally, let's tie it all
Now
together.
they're going to tie it in, right?
Because of each of the plaintiff's claims involve statements made and actions taken during the development, creation, production, display, and or performance of expressive works by a world-famous celebrity, the complaint is based on, quote, conduct in furtherance of the existence of the constitutional right of free speech in connection with a public issue or an issue of public interest that is protected by California's anti-SLAPP statute.
Very broad.
And totally not persuasive. I want to
No.
see you talk specifically about how that one particular instance is not a part or is a part of the exercise of your free speech rights. Like I didn't get any of that. I just got
Exactly.
this does not equal this. This
I
is not.
think 2 pages were spent trying to rebut all of plaintiff's facts with Lizzo-friendly facts to change the narrative, and now we're running into our page limit, and we have to quickly put this legal argument in a few pages, and it just misses the mark totally.
Agreed. Agreed. And this is me really wanting to like Lizzo's defense here, but I'm really struggling with if you're Lizzo, you should have access to the best labor and employment lawyers on the planet. And this, if this is what they got, I am highly unimpressed. Okay, the First Amendment guarantees freedom of speech and expression extending to all artistic and literary expression, whether in music, concerts, plays, pictures, or books, and live entertainment, such as musical works, fall within the First Amendment guarantee. Likewise, television shows, movies, and films are protected expressive works subject to First Amendment protections. The anti-SLAPP statute protects more than the exercise of constitutional free speech rights and extends to acts that in furtherance of those rights, to advance that right or assist in the exercise of that right. It is thus well settled legal precept that the creation, production, and distribution of expressive works are protected activities under the anti-SLAPP statute.
Okay. So here they are going to try to meet the first prong. Remember, they have to show that all of these factual allegations fall within these expressive works covered by the First Amendment.
Which they've only told us basically this was done as part of their employment for Lizzo, and Lizzo was producing Watch Out for the Big Girls and a tour. And so therefore everything that occurs is in fact part of her First Amendment, is protected by the First Amendment. And I struggle with that as a general argument because I don't think that the law intended to say that if you're a backup dancer, if you're if you work for a movie production company, or if you work for, you know, any entertainment business or industry, that employment laws just don't apply. That to
Right.
me does not seem to be like what the law is intending to do. Like, you still have an obligation as an employer to have a certain level of work environment that you must provide, which is free of discrimination, it's free of harassment, it's free of all
Hostile
of.
conditions.
Yes. So the idea that we are going to say that the anti-SLAPP statute allows Lizzo to treat her employees in any manner she deems fit, I just don't think is it. First of all, I don't think it's a good argument. And second of all, it doesn't change the narrative for me. You're just saying, again, back to what we kind of talked about before, you should just take it, or like you're complaining, you're
Right.
complainers, which I think is gaslighting, you know?
Mhm. I agree.
Okay, so courts have confirmed and extended the ambit of conduct, quote, in furtherance of the First Amendment rights. The Second District Court of Appeal held that a singer's selection of the musicians that play with him both advances and assists the performance of the music, and therefore is an act in furtherance of his exercise of the right of free speech. There, a plaintiff's FEHA claim for disability and age discrimination arose from his termination as a drummer in a popular singer's band. The court reasoned that the selection of a drummer is analogous to casting decisions regarding who is to perform music during a concert or studio performance, and thus is an act in furtherance of the exercise of free speech for purposes of California's anti-SLAPP statute. Okay, I mean, I think it's every employer's right to choose who works with them. The law says you can be, especially in an at-will state, which we are here in Louisiana,
Mhm.
the law says you can be terminated by your employer for any reason or no reason at all, as long as that reason is not a violation of the law. Here, what I feel like they're trying to say is that protection is not afforded to certain types of performers or musicians. And I don't believe that to be the case. Just because you're working as a backup dancer or a backup drummer doesn't mean that there isn't still some requirement not to be discriminated against. You have the defense that the reason that regardless of the reason of termination, that performer is allowed to choose their backup dancer, right? And that's what the court ultimately found, that if it's the selection of the person who's going to be with you on stage, and the reason that you chose to not have them on stage with you is because you don't feel like it advances the performance, then that is within your right, 100%.
Right.
You get to choose all of the people that support you in your ultimate performance where you're the headlining act. Does that mean, though, that you could fire them for other reasons and use this anti-SLAPP defense? I don't know.
No.
Yeah.
No, I'm fine with anti-SLAPP in the context of picking your performers, your drummers, your backup dancers, whoever. But to extend that to all of the conditions of employment and just their day-to-day role as backup dancers, I have a problem with that.
Yeah, and I think that that's where the analysis that we're missing is really supposed to come in, right? Like, is having somebody or is having a 12-hour dance rehearsal where somebody feels threatened and intimidated and defecates on themselves or doesn't go to the bathroom, like, is that protected by the First Amendment? And the answer to that actually could be yes, right? Because you're
Mhm,
in this active performance of developing the dance performance. So,
mhm.
you know, I can see that in that circumstance, Lizzo is allowed to be a tyrant. She wants the best dancers behind her. And if for whatever reason that they were not giving her that because they were not um, dancing well or forgetting things or whatever. But a lot of this stuff is just not within that realm.
No.
It
And
is not.
here they're about to try to get into it, but again, we understand, while they're on stage during a performance, while they're on stage during rehearsal, we understand that those fall within anti-SLAPP, but what about all of these other allegations?
Yeah. Yeah. So here, personnel management, negotiation of the terms of employment, providing feedback and criticism regarding performance and professionalism, termination of employees, and conducting personnel meetings are all activities fundamental to preserving the creative integrity of the special tour and constitute protected conduct. I think it's just too broad of a brush.
Me too.
Okay. Nor are acts in furtherance of the exercise of free speech limited to those that occur on set while cameras are rolling. Such an interpretation of the anti-SLAPP statute would rest on unreasonably narrow or constrained view of the creative process generally. And there they're citing a California appeals court case where actors and a producer or a co-writer of a comedy film testified that the creative process for a film was, quote, highly improvisational in nature and occurred when the camera was rolling and when it was not. Lead actors' racial jokes and use of a racial epithet off camera constituted protective activity. That's interesting, right? So typically any use of a racial epithet is direct evidence of racial discrimination. And so they're using this court case, this opinion, to stand for the proposition that even with regard to things that could be considered direct evidence of discrimination, if that was done as part of your First Amendment furtherance of your performance, then it is subject to the anti-SLAPP statute. So they are giving an example kind of what I said that I don't think they're able to do, which is to just say, generally, we're allowed to do whatever the hell we want because all of it is in furtherance of the anti-SLAPP statute. I think there's still a tie here, though, right? The actor did it off camera while the camera was not rolling, but it was all part of this production.
It was
Here we
on
have
set, right, and
and here we have several,
Mhm.
this is stuff that happens not on the clock, not in a performance, not outside of a performance. The banana bar and the crazy horse are just purely extracurricular activities.
Exactly.
Okay. Here, multiple witnesses testify that dance cast meetings, pre-show prayer circles, and cast outings were integral to the iterative creative process involved in the creation of Watch Out for the Big Girls and the production of the special tour. Okay, dance cast meetings, I got that. That makes sense to me. Pre-show prayer circles and cast outings are part of the creative process. I don't
Mm.
know if I'm buying that. Cast outings? I
Cast
mean,
outings. You're gonna have a hard time convincing me that these trips to the bars were related to her creative process.
yeah. I mean, we've all been in a job where you do go to have drinks with the boss on Friday, happy hour.
Mhm.
And a lot of stuff happens at that meeting, right? Like you're creating and developing your relationship with your boss, but it's not on the clock. It is certainly
Right.
an extracurricular activity. And people will go to that or not go to that as they can or cannot do so.
Mhm.
I don't see how this.
Lizzo would have to show here that she was taking ideas from these shows and wanting to incorporate them into hers, and
Yes. That would be
she
a great way. I think that that would just one simple statement like that could go a long way in trying to tie in why you would need to go to the banana bar and the crazy horse. But like for instance, the crazy horse is a really beautiful, amazing cabaret show. I think for a Lizzo style show, it would make great sense that you would go check out the crazy horse as an ability to get some ideas.
Mhm.
I don't see how though your dancers have to come with you to that. But again, they're trying to say it wasn't mandatory. It was totally voluntary. Again, when your boss asks you to go to something, oftentimes you don't feel like that is a voluntary type thing.
Right.
Yeah. Courts have declined to dissect the creative process or to characterize isolated occurrences as related or unrelated to the overall development of creative works. As California courts have recognized, the creative process must be unfettered, especially because it can often take strange turns, as many bizarre and potentially offensive ideas are suggested, tried, and in the end, either discarded or used. We must not permit juries to dissect the creative process in order to determine what was necessary to achieve the final product and what was not, and not to impose liability for that portion deemed unnecessary. Creativity is, by its nature, creative. It is unpredictable. Much that is not obvious can be necessary to the creative process. Well, this is a great piece of law for them.
Mhm.
100%. So it is actually this exact quote, which is why they felt, I guess, the ability to be so liberal in their just saying everything is a part of the creative process, because that's what this precedent is holding.
Mhm.
Now, I haven't read this case, and I would bet you anything that this case is not this broad. That they have to put something. I mean, you might not want the juries to be doing this, but at this stage, we're not in front of a jury. This is, an anti-SLAPP. This is the judge is going to make this determination, not a jury. So I don't know. I would need to see more about that case to see if it's as good of a law for them as they are claiming. And as we know, Megan, so often in these briefs that we get from opposing counsel take a lot of liberty in that regard.
Mhm.
Yeah.
If I'm a defense attorney here, I want to tie in my case like these as much as possible. I want to compare facts. I want to show that where the court held this was part of the creative process, here is all my similarities. So you should likewise find this is part of the creative process. And Lizzo's attorneys aren't really doing that here. They're just broadly saying courts don't look at what's considered creative. You shouldn't either. We're telling you it's part of our process and bonding. So just grant the motion to strike. And I don't think that's very persuasive.
Agreed. And I don't think that that's what the intent of the law really is for. So we'll have to see, ultimately what the judge says on this. But my sense is that this is great law for them. Again, the anti-SLAPP statute appears to be very, very strong defense and good legal grounds to try to get a lot of this dismissed. Um, they're just going about making the argument so broadly and so generally. And maybe it's from a page concern reason. Maybe it's because they truly think that the law really is so good for them here. That's another possibility for sure. All right. Do you want to pick up on this last section? about plaintiff's carefully choreographed media blitz surrounding the film.
Yes. So as soon as they drafted their complaint, they went on a lot of talk shows, a lot of news articles came out, all painting Lizzo in this negative light, reading some of these allegations. And so they are saying here that this was all an attempt to silence defendants' creative voices and weaponize their creative expression against them. That's a powerful sentence. I'm buying it. Because the actual objective of the suit filed by plaintiffs is to interfere with and burden defendants' exercise of free speech rights in connection with a creative work that claims fall within the ambit of protected activity under the anti-SLAPP statute. This should have been up at the top with the
Yes,
introductory paragraphs. That's
100%
what we've
agree.
been getting at the whole time.
Yes, this was a very strong. This to me is really strong for them because here they're finally getting to the point that it's all about eroding Lizzo's reputation as opposed to actually bringing these claims. So yeah, I think this was strong, a strong section. All right, talk to me about the issue of public interest issue and requirement.
So, in order to be free speech under the First Amendment, it's not all speech. It has to be a matter of public interest. And so here they're claiming Lizzo's status as a celebrity, her number of followers, her media attention makes her an item of public interest. And
And this
that
really
is
gets
required.
back to this idea that most of our employers are never going to have this, right?
No.
We're never going to get the defense that something that the employer did is protected by the First Amendment. And that's because most of the employers that we represent are not of public interest. But when you have a public figure like Lizzo, certainly Lizzo is an issue of public interest. Her whole persona is an issue of public interest. And I think that is due to the fact that she has so many followers, she has such a good fan base. And so they're saying that that standard is easily met here. Do you agree with that?
I do agree that, celebrities in general are a matter of public interest. Now, whether the activities that you're bringing a suit for fall within the ambit of that public interest, that's where I draw the line. So we have to see everything Lizzo does can't be protected under anti-SLAPP. But if you tailor it to her shows or the television show, then it falls within that category for me.
Interesting. Okay. So, and they're also talking about watch out for the big girls achieved popularity with audiences. And so they're saying it's not only just Lizzo, but it's also watch out for the big girls, which was a television show. So that makes sense. All right. So I'll give them that, right? That clearly, I think we're going to pretty easily be able to meet this element of the anti-SLAPP statute because Lizzo and watch out for the big girls is a matter of public interest. All right. So then because we've gotten to that, right? Because we've met that prong, now what is the second prong that we look at with regard to anti-SLAPP? What's going to happen now?
So, after defendants meet their burden of showing this is all protected activity because it's a matter of public interest, it's in furtherance of that creative expression, then the burden goes to the plaintiff again to demonstrate that they have a probability of prevailing on the merits of these causes of action. And that's really hard to do at this stage of a case because you don't have discovery, you don't have a lot of that evidence that you would need to show you have a probability of prevailing.
Yeah, that's why, I mean, this is a really great tool. I mean, a judge or a court is normally never required to make this type of a determination of whether or not the plaintiffs are going to prevail or have a likelihood of prevailing at this stage of the game. Like we've talked about, typically in a normal motion to dismiss or a motion to strike, you're asking the court to the court is required as part of the legal standard to accept as true everything stated in the plaintiff's petition.
Mm-hmm.
Here, that's not the case. And it's not a case because that's not the case because the judge or the court is now going to look at whether or not the plaintiff has not only made a prima facie case, but whether or not they have a likelihood of prevailing on that case. Okay, so let's talk about the hostile work environment, sexual harassment. Plaintiffs cannot prevail on their first cause of action because they cannot establish that they were subjected to unwelcome sexual harassment, that the harassment was based on sex, which is what I've said all along, or that the harassment complained of was sufficiently pervasive so as to alter the terms and conditions of employment and create an abusive working environment. Whereas here, plaintiffs have not alleged and cannot allege a tangible job detriment as part of their sexual harassment claim, the absence of such detriment requires a commensurately higher showing than the sexually harassing conduct was pervasive and destructive of the working environment. Okay, so now they're making the arguments that I feel like should have been made and introduced back at the beginning of the complaint, right? Like we're getting into the nuts and bolts of whether the allegations actually meet the legal standard in order for us to get a legal claim. But we're just now bringing this concept here. And we're on what are we on? Page 20 of 25. So we're right here at the tail end. And now we're talking about, okay, you don't have the ability to prove this. And look at this. They agree that under the FEHA, it's the disparate treatment of an employee on the basis of sex, not the mere discussion of sex or use of vulgar language, that is the essence of a sexual harassment claim. Yes, finally, this is 100% correct. You have no sexual harassment claim. You could have started here because this had nothing to do with anti-SLAPP or not. And I don't think you have a sexual harassment, hostile work environment claim at all because it is required to be on their basis of sex. The reason that they were treated differently has to be because they were women. Well, how do you make that? I don't get that. There's not any facts in this complaint which ever get to that particular requirement that I saw.
And so it's interesting strategically that they use the second prong of the anti-SLAPP statute to make these arguments instead of your typical, like we would use in federal court, a 12b6 motion, no cause of action. Here they only use it in the context of anti-SLAPP.
Which, okay, I'll give them that. That does make some sense from maybe a page count perspective, right? They only have 25 pages. They need to make these arguments. This is a slam dunk argument, though. I mean, to me, it's like regardless of anti-SLAPP, I think in putting it here in the anti-SLAPP section, they're getting the result of both. If you didn't think it was all of these allegations fell under the performance guise, then let me show you how even still they don't have a likelihood of prevailing. So, okay, maybe it's just not organized in the manner in which I'm accustomed to seeing, but I would have loved, at least as part of the introduction, for them to say that they have failed to sustain enough or allege enough facts to support a legal cause of action for sexual harassment. Why? Because there's not a single statement that the reason that that the environment was what it was is because they were females, right? It wasn't a bunch of male management that was imposing this sexually charged environment on a group of female employees. That's simply not the case. There is literally nothing tying the sexual harassment, hostile work environment claim to this concept that the reason that it was like that was on the basis of sex. It was because they were women. There is nothing in the case.
And same thing with the racial discrimination part of the complaint.
In fact, yes, exactly. Like with regard to the racial discrimination, okay, they say in the racial discrimination complaint that the management of the touring company was all like Caucasian males, like older. I forget if they call them Caucasian, but the word that you're kind of left with is you see a bunch of like white men being in the management of the tour company, which I've got to say, I'm really disappointed if that's actually the case because like Lizzo hires these people. Lizzo gets to choose who is the management team And the idea that Lizzo would have chosen a bunch of white guys to do that is like really concerning to me and like very bothersome. Um, maybe
But
that's
then she also is the head honcho and the boss of her tour. So if you're
she's
gonna
the
make a
CEO.
racial discrimination claim, it can't be against someone who is the same race as you.
Well, and they hired, right? Who they end up hiring to be on Lizzo's tour to replace these girls. Guess who? They're going to be heavy set African American women or
Mhm.
brown. That's all of the dancers. That is what the dancers look like. And so, one of the ways in which you're able to prove racial discrimination is to show that the person that was hired after you actually is white or is skinny or, now look, weight is not a factor. It's not a protected class. So
Yeah.
they throw that in there, but that's actually not a protected class in terms of employment. What is protected is racial discrimination. You're not allowed to be discriminated on the basis of your race. Here, there's going to be no way for them to show that or for them to prove that they were discriminated, except as it relates to the male management dealing with the dance team on the pay issue.
Mhm.
That's where I see that you might have a real discrimination claim. Okay. Under these circumstances, plaintiffs cannot establish that they suffered harassment on the basis of sex or that any arguable harassment was sufficiently pervasive. So they make both arguments. Like, not only was it not on the basis of sex, but also it's not severe and pervasive as to alter your terms and conditions of employment. It's a
Mhm.
pretty high bar in federal court for you to meet that standard. Um, you know, we've got a lot of bosses that we know that have made, offhanded, very poor, inappropriate comments at work. But there's so many cases that you'll find in federal court where they simply say somebody can make those statements, but unless it's severe and pervasive and it alters the terms and conditions of your employment, it doesn't mean that there's anything that the environment constitutes sexual harassment. So I think they're making a great argument here. Failure to prevent or remedy hostile work environment or sexual harassment. Well, this is pretty easy of a claim, right? If you find that there was no sexual harassment, then there
So
is
it
no
can't be
failure
a
to
failure
prevent.
to remedy.
Yeah,
Right.
yeah. Okay, and that's basically what they say here, that the evidence shows that the plaintiffs were aware of the procedures for reporting alleged sexual harassment and that the one time that they did make a complaint, the matter was taken seriously and swiftly and appropriately dealt with. The plaintiffs did not complain about the laundry list of other purported sexual harassment to the tour management, Quigley, and Van defendants cannot be held liable for allegedly failing to prevent something about which they did not know. So,
Employers, this is where it's important to have both a handbook and personnel files where you document these sorts of grievances in accordance with your handbook.
yeah, but they don't allege that they acknowledge in the complaint itself that they failed, that they, in certain instances, they say management knew. They don't
Mhm.
say how management knew, but they do say management knew and failed to take action for it. But there are definite instances where they say they didn't even report it to anybody.
Right.
Okay, religious harassment. This one was such an odd claim to me. I'd never heard of this idea of religious harassment. I've always seen it couched as like religious discrimination. And we had talked about in episode 2 how really they kind of use harassment and discrimination in the FEHA statute kind of analogously.
Mhm.
um, all right, so let's look at what they argue here. Why don't you take this one?
Sure. To prevail on their claim for FEHA religious harassment, plaintiffs must establish that they're members of a protected class and were subjected to harassment because they belong to that group, and that the alleged harassment was so severe or pervasive that it created a hostile work environment. Plaintiffs cannot establish that they are members of a protected class based on their religious belief, observance, or practice. At best, they allege they did not share Quigley's religious beliefs or wish to pray. Even if plaintiffs did allege that they were subjected to harassment because of their membership in a protected religious group, they cannot prevail unless the conduct would have interfered with a reasonable employee's work performance and would have seriously affected the psychological well-being of a reasonable employee that she was actually offended. So I guess they're saying being subjected to this prayer circle isn't enough to account for religious harassment. It has to be so unreasonable that it affects your psychological well-being.
I think, there's a lot in the complaint about Rodriguez not wanting to play or not wanting to pray and being like actively anti-religious. But I mean, so it's interesting. She's anti-religious, right?
Mhm.
She does not believe in Christianity, but is that are you part of a protected religious group? I think so. I think you still would be part of a protected religious group, but that's certainly something that they're trying to get out here, is that
Mhm.
just because you don't want to pray doesn't make you a part of a protected religious group.
Right.
All right.
Multiple witnesses confirmed that there was no pressure or requirement to participate in these pre rehearsal or pre show prayer circles, that Quigley did not treat anyone differently because of their religious beliefs, and in fact explicitly told Rodriguez that she did not need to participate in any prayer if she did not wish to, and that no one was attacked or harassed on the basis of religion or subject to adverse employment consequences based on their faith, or I guess here, lack thereof. So they would have had to show that they were targeted as, atheists or anti-Christian, whatever they were, that they were specifically targeted and discriminated because of that. When here, defense is saying that didn't happen.
Okay. And then we've got the same kind of corollary where they're going to say, look, because there was no religious harassment, then we cannot be assumed or we cannot be required to prevent it because you never told us about it.
Right.
So Quigley was a representative for the dance cast members and helped with rehearsals on the road, but did not actually direct or supervise the dancers or have any hiring, firing, or casting influence or authority. Plaintiffs do not allege that they ever reported Quigley's alleged religious harassment to tour management, BGBT, or Lizzo. Without acknowledgement of the alleged harassment, defendants cannot be held liable, nor can defendants be held liable for failure to prevent or remedy harassment that did not occur. So they're saying, look, this was never religious harassment to begin with. And then even if it was religious harassment, we didn't know about it, so we cannot be held to have known about it. And this really, the legal crux of this really relates to Quigley's role.
Mhm.
So employers are on the hook for their managers, and their managers really the key to whether somebody is a real manager is if they have the ability to hire and fire.
Mhm.
That's what courts have said time and time again. And so what they're doing here is saying Quigley is not a manager. Therefore, we cannot be on the hook for anything that Quigley did. We talked in the first or second episode of this podcast about how in California, you can actually be held individually liable, even if you're not a manager. And so I think that there's still some issues for Quigley here, but I think that BGBT and Lizzo are probably going to get off the hook. There was a sentence in the original complaint where they said that somebody had reported it not only to Quigley, but then they had gone to the choreographer. And I wonder, I bet you anything that the choreographer is a manager. So Quigley might not have been a manager, but who they reported it to was a manager. And if that knowledge got to a manager, then guess who has knowledge of the issue? And I think that sentence is pretty good and is going to leave this in. That's what I'm going
Mhm.
to is that ultimately I think they're not going to be able to necessarily get rid of failure to prevent religious harassment because she told a manager and still nothing was done about it. The manager told her actually to go take it up with Quigley. So that is a failure to address for sure.
Right. Yeah.
Okay. Now on to the racial harassment.
And we kind of touched on this earlier where, you have to look at whether the person doing the harassing is of the same race as the plaintiff. And here, if they're saying everything was done by Lizzo, then you don't have a racial harassment claim. It's going to depend on those tour managers.
Okay. And then also they're showing here that that the harassment has to interfere with a reasonable employee's work performance and would have seriously affected the psychological well-being of a reasonable employee. In that regard, harassment cannot be occasioned, isolated, sporadic, or trivial. Rather, the plaintiffs must show a concerted pattern of harassment of a repeated, routine, or generalized nature. Davis and Williams cannot and have not demonstrated that isolated statements about the dancers' behaviors were racially motivated. None of the other performers experienced or witnessed racial discrimination. To the contrary, criticism of Davis's and Williams' performance of their job responsibilities was warranted because they were not performing up to standards and were not acting professionally, having nothing to do with their race. Okay, there isn't, the way in which the petition or the claim, the complaint is drafted, they focus a lot on kind of a stereotype, like it's a trope. I think they even use the term trope of this idea that generally it's a stereotype that African American women who are heavy are lazy. And so they don't do a lot of, they say that this white management used those regularly to talk to all of the dancers, but here they're going to offer up all these other dancers' declarations who say they didn't hear that. So that's certainly good evidence against that. Again, back to the she said issue, though. And then also, they're making it just about these individuals as opposed to being a racial issue. And I think that is kind of a good point. Back to what we were talking about before, it's going to be really hard to say you're racially discriminating against us, and it's because I'm a member of a protected class, I'm African American. But if they're not doing the same to the other 17 dancers who are also of the same race as you,
Right.
can't use that to demonstrate as evidence to show because you're being treated one way. In fact, it demonstrates the opposite, that the reason that you are being singled out has nothing to do with your race, but everything to do with the fact that you are not performing up to snuff.
Exactly.
Yeah. So I think they have a huge problem there. Okay, why don't you handle the disability discrimination?
Sure. To show a prima facie case of disability discrimination under FEHA, a plaintiff must show she's a member of a protected class, she was performing competently in the position she held, and she suffered an adverse employment action such as termination and some other circumstance that suggests a discriminatory motive. Davis cannot establish that she was performing competently or in or about late April and early May 2023. Multiple witnesses attest that she seemed emotionally unstable, did not have energy in rehearsal or performances, danced sloppily, was observed throwing up backstage between numbers during shows, and publicly urinated on herself. Defendants actually offered accommodations to protect Davis's mental and physical health. Other performers, including dancers and musicians, found defendants to be accommodating and understanding when they faced health issues or left stage during rehearsals and production run-throughs. Davis cannot bring a claim for discrimination because she chose to decline the accommodations offered by BGBT. And this is what we discussed earlier. Is time off that's unpaid an actual accommodation? I don't think so.
I don't think it's a great accommodation. I guess you're saying, well, keep your spot, but they didn't say that. I don't think.
No.
They didn't say, hey, you can take a break, your spot's safe, you don't have to worry about it. Do you that's not how the conversation is at least painted in the petition. they don't really seem to counteract that, although they do reference these declarations here of all of the other dancers. Do we know who? I don't know who was in that particular meeting. It was maybe the choreographer that was with Davis and Lizzo. But I'd be very interested in reading that declaration as well. Okay, finally, we've got intentional interference with prospective economic advantage. Then we're going to have the assault and the false imprisonment allegation. And those are going to be the last three that we have. Again, we've talked about the intentional interference with the prospective economic advantage. Here, what they're saying is that you have to know of an actual economic relationship and a future economic benefit or actual disruption of that relationship by the defendant's independently wrongful conduct. Alleged interference must be independently wrongful beyond the fact of the interference itself. In accordance with industry standards, a performer being paid a retainer is expected not to take any jobs that may interfere with performance obligations to the artist paying them. Plaintiffs were informed of potential performance dates as soon as possible, with the caveat that things could change, hence the use of the phrase soft hold after plaintiffs were placed on a retainer.
Do you think to meet this standard, they would have had to show they were offered some other group's tour, another performance?
I think you have to show an act, like to me, the key word is the actual disruption of a relationship. And we had the allegations that were given were too general. They don't say, Madonna came and offered Davis the opportunity to perform on her tour. It's very general that she just went to the choreographer and said, I've gotten the chance. And that choreographer says, like, basically, you better, if you want to keep your job here, you're going to not take any other jobs. Well, I don't think that bare bones recitation of facts, I don't think that rises to the level of an intentional interference with prospective economic advantage, which has to be an actual contract that was denied or messed with. And that's never alleged here.
Right.
They don't make that argument, unfortunately. I don't know what that says about my legal brain, but I just feel like that's the argument that should be made. Okay, then we talk about assault. I mean, again, back on the assault issue, I don't see at all how they're able to get assault or false imprisonment into the realm of part of a performance.
Right.
I mean, it is part of the talking to the dancers and that whole thing, but I don't know. A claim for assault requires proof of 1, an act committed by defendant with the intent to cause plaintiff's apprehension of immediate injury, and 2, reasonable apprehension of immediate touching. In addition, mere words, however threatening, will not amount to assault. Lizzo did not act with the intent to intimidate Rodriguez. Multiple witnesses confirmed that they did not believe that any physical altercation between them was imminent, and that Lizzo did not physically intimidate or approach Rodriguez. Rodriguez's purported apprehension of an immediate touching was unreasonable. I don't see how you get rid of this here. I mean, that is a full, somebody is going to have to make a factual determination of whether or not, I mean, Rodriguez says she was in fear in her allegation. Okay, so now using this standard, the court has to say, like, well, does that rise to a level of a reasonable person standard? And since all of these other people said they didn't feel that way, then this should be dismissed. And I don't think I don't think you're going to be able to get rid of this.
And it's also, where do you draw the line? If, okay, during the creative process on set, but the cameras aren't rolling, you're allowed to make these racial comments, okay? They held that was within anti-SLAPP. Are you allowed to, threaten someone with assault? Are you allowed to assault them and it all be protected? I think you have to draw a line somewhere, and here's where it should be drawn.
Okay, but so let's say it's not protected, that type of conduct is not protected. Now what the standard that the court has to say is, okay, are plaintiffs, do they have a likelihood of prevailing on that claim? And plaintiffs, I mean, there is no doubt that they have alleged with specificity facts that support their claim here.
Right.
So the court would have to find that these other declarations, that this other testimony is so persuasive as to negate plaintiff's reasonable belief or plaintiff's own statement that she believed she was being physically intimidated. I don't see the court kicking this one out.
I don't either.
Okay. Same. I think let's talk about false imprisonment, but the elements for false imprisonment include non-consensual intentional confinement of a person without lawful privilege and for a period of time, for an appreciable period of time, however brief. However, detention carried out for a reasonable time and in a reasonable manner by an owner of property or employer investigating wrongdoing such as theft is privileged. Consent is also a complete defense. Ooh, I think that's very, very smart. Here, Davis has no evidence that she was restrained against her will. She was free to leave through the door to the conference room and was not physically restrained or threatened by the defendants. Davis, by her conduct, consented when she remained voluntarily with her phone in hand, scrolling through her video and audio recordings to confirm for tour management that she had deleted all copies of the unauthorized recording and then parted with them amicably. And there we go. That's the end of it. All right. So that takes us through the entire motion to strike from the defense team. Megan and I obviously were somewhat disappointed with the strategy I think the defense used, or really the structure of the defense's motion to strike. While we were recording, we also had some news from Lizzo herself recently out in the media where Lizzo decided that she was going to quit. Let's pull that up really quickly. Let's go through that. Megan, did you get a chance to see that?
I did, and it was pretty shocking to me.
I'm getting tired of putting up with being dragged by everyone in my life and on the internet. All I want is to make music and make people happy and help the world be a little better than how I found it. But I'm starting to feel like the world doesn't want me in it. I'm constantly up against lies being told about me for clout and views, being the butt of the joke every single time because of how I look. My character is being picked apart by people who don't know me and disrespecting my name. I didn't sign up for this shit. I quit. Yeah, that's really sad to see that statement by Lizzo. And I can only imagine, I've certainly had clients in this situation before where they really take all of this very personally and take it to heart, and it becomes very overwhelming for them. So certainly Lizzo is not alone in feeling like this whenever a lawsuit is filed against her. Certainly it's calling into question her character. And so that's very, I'm sure, traumatic and hard. From a PR perspective, what I would tell a client in that circumstance is that, the best defense is always a good offense. And, but sometimes accountability and taking some accountability is required. She has yet to really say anything in addressing this other than just everything that they're saying is a lie. And that doesn't ring true either. They always say, there's the truth, there's like side A, side B, and then, the real truth is somewhere in between. And everybody innately believes that. So, what are your thoughts?
I think it's interesting that she's saying she quit after filing this motion to strike, because if this gets granted, it's kind of like a win for her. So, she wouldn't have to quit the music business if all of this was found to be unfounded or to not able to move forward, and she would be done with it. So, it's interesting to me, the timing of it all.
Yeah.
But also, eager to see what the judge does with this motion to strike, if he feels the same way we do on some of these allegations.
Well, stay tuned, folks, for the next installment where we're going to go over the judge's order and see what stays in and what gets kicked out. Thanks so much for being with us here on Pop Your Biz. For the time being, have a great day. We've linked all of the things into the notes below that you might want to look at independently. Give us some comments, some feedback. Let us know thoughts or comments that you might have. And until next time, we'll see you then.
See you later.
Thanks for joining us today on Pop Your Biz. For more information about my law firm, Business Law Group, check out our website at www.lawgroup.biz. You can also find us on all the major platforms, including Insta and Facebook, as well as LinkedIn. As always, if you liked this content, I really appreciate your positive reviews, comments, and sharing this show with others.